proceed. And we start with a question from Maura Mwenga. It's your turn.
Good evening, Mwalimu.
Yes, good
I
evening.
I had a question on duplicity. I was being confused somewhere. There is a place you told us that some certain offenses can give you duplicity without you knowing. And you gave us an example of human trafficking. But as I was going through the notes and even listening to the recording, I wasn't getting how.
What is human trafficking? Have you read Section 2 of Human Trafficking Act, the Anti-Human Trafficking Act?
No.
That is why you're not getting how. So you need to go and check it out, and then you'll get how. So read Section 2 on what is human trafficking, what amounts to human trafficking, and then you can answer the question again under Section 2. Okay.
Okay, Mwalimu.
Okay. Anybody else? Yes, Alingo.
Yes, Mwalimu, I hope you can hear me.
Yes.
Okay, now, Mwalimu, my question goes to, I know we haven't discussed this, but it deals with admissibility of electronic and digital evidence. So, if for example, the electronic or digital evidence, let's say audio and video, are presented in court as evidence, under what circumstances can we say that particular evidence will not be admissible in court, disregarding the fact that it is not a requirement for it to be produced in its original form?
Have you read the Evidence Act from Section 79 on production of documentary and video evidence?
Yes, actually, it's Section 78. It says that in any proceedings, electronic messages and digital material shall be admissible. And then now it provides for the rules on admissibility of that digital evidence. But my question tends to like, under what circumstances can it not be admissible, or is it that
isn't the act providing for rules of admissibility?
Yes, it does. Or
what is the first rule of admissibility?
Well, the first rule is that the evidence itself must be admissible. The second one, the evidence itself, the audio or video should be reliable. Should be complete.
Okay.
Authentic and believable. So if it does not satisfy any of these rules, can it be regarded to be inadmissible in a criminal court, Mwalimu?
No. Remember, we have the rules of admissibility. We have admissible evidence, and we have evidence that is not admissible. That is part of Evidence Act. There's certain evidence that are not admissible in court. Okay. For instance, evidence regarding communication between spouses, they are not admissible in court. They are privileged communication, and they're not admissible. Evidence that are dealing with documents of the government, for instance, questions to do with national security, they're not admissible in court. Evidence that are relating to the communication between an advocate and their client, that is not admissible. Okay, so what we are simply saying is it must be an admissible evidence. Look at Section 124 on the question of admissibility going down. Which evidence is admissible in court? Which evidence is not admissible in court? So if you take a video recording of an advocate speaking to another client, that is not admissible. So even though it is an electronic evidence, it is not admissible because it does not fall does not meet the requirement of admissibility. So there's an entire discussion on admissibility of evidence under the Evidence Act. Start from 120, should be 124, going down. You will find evidence that is not admissible. So if you are going to bring documentary evidence, for it to be admitted as evidence, it must be an admissible evidence. It means whatever is contained in that audio recording should be something that is admissible before the court. But if it is not admissible, then that is not a documentary evidence that can be taken by the court. I don't know whether we are moving towards understanding.
Yes, Mwalimu. Yes, Mwalimu. In my understanding before, you have cleared that. I was like, as long as it is video or audio, it is admissible. But since you have you have stated the circumstances, I will definitely look at section 124, Mwalimu. Thank you.
Not all evidence is admissible. Some evidence are not admissible. There's certain evidence that also require corroboration. They must be corroborated. So if you don't, for instance, let me give an example of confession. If you don't, there are rules of confession. For confession to be admissible in court, there's certain things that must be done. You need to confess before an officer with a rank of at least an inspector. So it means if you are tortured into confessing, and then they record that audio recording of you confessing, it is a video evidence, it is electronic evidence, but it is not admissible because it is one that is obtained through unlawful means. That is, could be through torture or anything. So the evidence itself must be admissible before it can be regarded as an admissible electronic evidence. Tunaelewana?
Yes, Mwalimu.
All right. So, any other question? Thank you. Do we have any other question that I've not addressed that I need to address quickly? All right, so let's start. I want us to start from where we left in the last class, and I want us to go very fast. Guys, remember that we have had a discussion. My intention is that we clear criminal this week so that we can embark on past paper revision from next week. So remember that we've had a discussion from the very first time to this very day, which sums up a total of 12 classes. We have gone through the very first thing, that is the principles of criminal law, all the way to investigations, arraignment, charges, plea, bail, pretrial, the trial process, sentencing and judgment, and we have gone through revision, remedies against judgment. Now, today I want us to start from where we left, that was revision, and quickly just brush through revision. We said revision is a revisionary power of the High Court. Revision is the power that is given to the High Court in very specific circumstances. If you look at section 362, you find that revision is given to the High Court alone for purposes of correcting and calling for records before magistrate courts and other subordinate courts with a view of correcting them. Okay, so that was revision. So we say that revision must only be sought at the High Court. There is nowhere else that you can seek an order of revision. There is nowhere else that you can seek an order of revision. It is only sought before the High Court. Okay, and that means that if you are told that the proceedings in questions were handled by the High Court, then of course revision is not available at that specific stage. And then we said that if you are going to approach the court for revision, you need to make an application. Of course, that is a notice of motion and a supporting affidavit. And in your prayers, of course, you have to indicate what exactly do you want revised. Now, remember, at the point we are having revision, there are two things. Actually, there are three things, but generally, there are usually two things. The first one, there's an order that the court has made. There's an order that the court has made, could be through an application. There's an order that has been made. Number two, a second thing that is there at the point we are having revision is the question to do with a conviction. Somebody has been convicted. And then number 3 is a sentence. So at any time you're making an application for revision, you are challenging the 3 things. The first one is an order. Any other order that the court might have made during the proceedings will be regarded as an order. And then apart from that, we have now the conviction, that is judgment, and then we have the sentence, which is the punishment at the end of the case. Now, when you file your revision application, you are either challenging the three of the things. The first one is the question to do with the order. This could be an interim order that the court has made through the trial, and then the final orders, which is conviction and sentence. That is when you can apply for revision on behalf of your client. So assuming that you are applying for revision, what are your prayers? Your first prayer normally is at the court. And before I mention the prayers, remember I said one thing in the last class. I said that in criminal, we don't have the review that we have in civil. We do not have that review that we have in civil. In criminal cases, we don't have the review. However, revision is also regarded as a review power. When the court is revising, exercising the jurisdiction to revise, it is deemed in the normal English language that the court is reviewing. Okay, so if you are filing an application for revision, you're simply inviting the High Court to review the decisions of the magistrate. So if you're told, please make an application to have this order, judgment, or sentence be reviewed by the court or by the High Court, then essentially we just talk about revision. So in criminal, revision and review are used interchangeably, but of course, the actual power is, the actual jurisdiction is the jurisdiction when it comes to revision. That is 362 of the CPC, as well as 364, as well as 354, 5658. These are the ones that provide for the powers of court during revision. Powers of court during revision. Please make sure you understand that specific the specific angle. Are you together? Now, any question? Joy? And these are things we discussed in the last class.
No, no problem. Yes. No, I'm just repeat the sections. That's it. Please. Thank you.
What section?
For the CPC that govern data for revision.
362. 362, 364, 354, 358, 356, 358. Those are the sections that provide for revision. As well as the constitution.
Naenda mbio sana.
These are things I discussed in the last class, so I need to move very fast. This is just a recap of the last class. So that's why I'm moving very fast. So we discussed those in the last class. I was just doing a recap of what we discussed in the last class. So some of you are in that class, you have recordings for that class again. I don't want us to go and discuss what we discussed in the last class. So that was the powers of revision. And I said that when you go to the High Court for revision, you are asking the court to review and set aside. Review and set aside. Now I've said revision and review are used interchangeably, but the actual jurisdiction is revision. Are we together? So you review and you set aside the order, okay, dated this by the magistrate court. If it is a sentence, a conviction that you are challenging, you quash the conviction, the court to review and quash the conviction. If it is a sentence you're challenging, you set aside the sentence, the court review and set aside the sentence. Okay, that is how you deal with questions to do with revision. So if you're challenging an order, you want the court to number one, okay, you want the court to review an order, review and set aside an order, review and quash the conviction, review and set aside the sentence. And then after that, you tell the court what you want. Okay? So if an order was made, let's say an order for bail, the court made an order and denied your client bail. We have said time and again, you don't appeal that decision, you apply for revision. So you'll be asking the court to review and set aside the decision of the magistrate court. Could be given the date of that decision or the decision itself or the order itself. Okay, the court review and set aside the order dated or the order by the magistrate dated this day. And then secondly, once it has been set aside, now you want the court to admit your client to a better bail term. Remember that the Constitution provides that every person has a right to the reasonable bail terms. What if it was a conviction? Now, that will depend with your client. Like we saw in the questions we did, if you go to this to the questions we did in the last class, you will find that your client will normally tell you what they want after you review. After you set aside the conviction and set aside the sentence, then your client will tell you what they want. Okay. Now, in talking about the powers of court during revision, which is also the same powers of the court during appeal, the court will set aside the sentence, okay, and maybe reduce the sentence or acquit the accused person. Or the court may quash the conviction, set aside the sentence, and refer the matter back for a new trial. Are you guys together? So that is within the jurisdiction of the court. So if you are dealing with a sentence or a conviction, you first pray that it be reviewed and set aside, or it be quashed if it is a conviction, and then you pray for what you want. Okay, you pray for what you want. The accused person be acquitted of the charges, or the court to refer the matter back to the magistrate or the trial court for another trial. It could be a new trial, depending on how you want to call it, a retrial or a new trial. But remember that it is not the retrial under section 56, article 56, sorry. So that is what you need to understand in as far as revision is concerned. Any question?
No questions, sir.
No question.
Okay, sawa. We are all good. Now let's go today and talk about the second part, the second remedy against judgment, which is the question to do with appeals. A question to do with appeals. Now, assuming that you want to appeal, remember again, guys, I said that at any point your client has been convicted and has been sentenced, there are only three things available. Okay? The first one is revision. That is the first one. The second one is appeal. The third one is retrial. So retrial is an instance where you are petitioning the court or making an application to court to have the court grant a new trial based on the new evidence that has come up. I will talk about that. So those are the three options that are available for you. When it comes to revision and appeals, they move on the same timeline. The same timeline for appealing is the same timeline for revision. It means you cannot apply for revision if time has passed, time has lapsed, the time for appeal has lapsed, unless you've been specifically told to do that. That means that leave has been granted, or it is assumed that the time has not lapsed. So that is, let me pull up my screen in terms of appeals. If there's a question, please feel free. All right. Hope you can see my screen. All right. So when it comes to appeals, guys, this is where you are appealing a decision of the court, and more so a sentence or a conviction. You are appealing that either to the Court of Appeal or the High Court. Remember that the Court of Appeal is the court of last resort, so it is either the High Court or the Court of Appeal. Are we together? Now that is appeal. You're moving to the next court, and you're not moving to the next court just to revise. You're moving to the next court to appeal and to prepare the appeal documents. That is what we are calling appeals. Now, for you to understand appeals, feel free to tell me if I'm moving very fast, because this is something we have not done. So feel free to slow me down if I'm moving too fast. Because of time, you let me know. Now, in terms of appeals, there are certain things that you need to understand. Okay, the first one is the right of appeal. Okay, the right of appeal. Now, the right of appeal is provided for under the Constitution, and therefore every accused person shall have the right to appeal. Every accused person shall have the right to appeal. It means at any point you do not need the leave of court to go and appeal. So that is the right of appeal. Now, the second element of that right of appeal is two things. The first one is appeals by the DPP. Appeals by the DPP. And then we have appeals by somebody that pleaded guilty. Okay? Appeals by somebody that pleaded guilty. Together. That is the second thing. The third thing that you need to understand, after all the appeals by the DPP and then appeals by a person that pleaded guilty. So how does that work? Let's start with the first one, guys. Am I too fast, too slow? Are we together?
We are together, sir.
We are together.
All right. So you can see my screen. You can see my screen. Somebody read for us 347.
Appeal to High Court. Save as is in this part provided. A person convicted on a trial held by a subordinate court of the first or second class may appeal to the High Court. And 2, an appeal to the High Court may be on a matter of fact as well as on a matter of law.
Thank you. So appeals are very simple. When it comes to criminal appeals, they're very, very simple. There's nothing complicated about appeals. The first thing you have to understand is the right of appeal. So we have said that the accused person shall have the right to appeal automatically, and they don't need leave to appeal unless they're appealing out of time. That is the first one. The second one is that the DPP originally did not have the right to appeal. Okay, the DPP under Section 348A did not have the right to appeal. It was only after 348A where the court or the law, the parliament, granted the DPP the right to appeal. So essentially, the DPP could not appeal. If you prosecuted a matter and you lost, then that would be the end of that case for the DPP, and therefore they could not appeal. But 348A has been amended, whereby the DPP can as well file their appeal. If the DPP feels like you've been acquitted unfairly or unprocedurally, the law has not been considered in terms of you being acquitted, then the DPP might go to court and appeal the decision of the magistrate or the decision of the High Court, depending on which court or what offense you were accused of. Are we together?
Yes, Mwalimu.
Okay. That's right. The next thing, The next thing that I want us to understand, in terms of still the right of appeal, is the right of appeal of a person that pleaded guilty. Guys, when you go to court and you plead guilty, you can't appeal except if you're appealing against the sentence. Somebody read for us 348, 349, sorry.
Section 349, limitation of time of appeal. An appeal shall be entered within 14 days of the date of the order or sentence appealed against, provided that the court to which the appeal is made may for good cause admit an appeal after the period of 14 days has lapsed, and shall so admit an appeal if it is satisfied that the failure to enter the appeal within that period has been caused by the inability of the appellant or his advocates to obtain a copy of the judgment or order appealed against, and a copy of the record within a reasonable time of appealing to the court therefore.
All right, thank you. Now, that is the question of the limitation of time. Where we are saying that if you are going to appeal, then 14 days is all that you have. 14 days is all that you have. So what is it that you need to file when you're going to appeal? We are going to look at that in a second. So guys, at this moment, you need to understand a few things. The first one is the right of appeal. The DPP, the accused person can appeal. The DPP can also appeal as well. Okay, as per the amendment under section 348. Okay. Number 3 is the right of a person that pleaded guilty. Now, I said, guys, that the moment you come to court and you are told, person XYZ, you've been charged with this offense, and you say, yes, I did it, then you shall not appeal against the conviction. So 348 provides no appeal on a plea of guilty nor in petty cases. So no appeal shall be allowed in cases of an accused person who has pleaded guilty and has been convicted on that plea by a subordinate court, except as to the extent or legality of the sentence. So any person that pleads guilty, guys, you need to understand this concept very clearly. Any person that pleads guilty, if you plead guilty, you cannot challenge the conviction because you've been convicted on your own plea. Guys, I said there are two things you need to understand. The first one is a conviction, the second one is a sentence. Now, a conviction is the answer to whether you did whatever you're being accused of doing. Now, when you plead guilty, automatically you have confirmed that I did it. And therefore, we do not need a hearing in this instance. We just proceed and sentence you. Now, a sentence is the punishment for doing whatever you did. Are you together? The punishment you are going to get for doing that you're accused of doing, which you've been convicted, is called the punishment, which is the sentence. Now, when it comes to a plea of guilt, you cannot appeal on the conviction or against the conviction. You can't challenge the conviction. Because what are you telling the court when you're appealing against the conviction? That I am not guilty. But you said you're guilty. Okay? There are only two instances, or there are certain instances where you will be allowed to appeal when you already pleaded guilty. The first one is if you are challenging the legality of the sentence. Legality of the sentence. So what is the legality of the sentence, and how do you know that a sentence is legal? Now, the first one is that this sentence is provided for under the law. Number two, this sentence is within the limits provided under the law. Are you together? So if your client has been accused of stealing, and the offense of stealing attracts a penalty or a sentence of 10 years, up to 10 years in prison, then if your client has been convicted to, let's say, hard labor, okay, let's say 30 years of hard labor, that is not provided for in law. It is an illegal sentence. Or if your client has been convicted to, convicted of this offense and sentenced to 11 years, that is also illegal. So how do you do that? You go to the question, you read the question, and then you'll be told this person was charged of this offense, and then it was sentenced to this. The first thing you do is open your penal code, run to the section where that offense has been created in the penal code, and then read the maximum sentence allowable. If the maximum sentence allowable is less than what has been provided for in the question, then that specific sentence is illegal. So the sentence must be in the law. You know the principle of legality: no punishment without the law and no crime without the law. Now, the sentence must be within the law, but at the same time, the court must restrict itself to the sentence provided for in law. So you can't, if the sentence is, if the sentence is 3 years, an imprisonment term of 3 years, you can't have 4. Okay, so that is what you're saying. So if you pleaded guilty to stealing chicken, stealing is an offense that attracts, let's say, 10 years, and you've been sentenced to death, then you cannot appeal against your conviction because you already pleaded guilty to stealing. But you can appeal against the sentence, whereby you are saying, I agree, I did what I'm being accused of, but this sentence is too harsh in the circumstances. The offense that I did is not supposed to attract this much of punishment. So you cannot appeal against the conviction if you pleaded guilty, okay, unless you are challenging the sentence, the legality of the sentence. Are we together up to there? That is the first one.
Yes, sir.
Okay. The second one is where the plea of guilt was not recorded as per the laid down procedures. So when you look at the case of Adam versus Republic, which we have talked about in this class in around 3 times, Adam versus Republic. Now that specific case lays down the ground rules or the conditions that must be met when the court is recording a plea of guilt. For instance, the accused person must be read to, the charge or the substance of the charge must be read to the accused person in a language that the accused person understands. Okay? Now, if it appears later that the sentence, or not the sentence, but the charge was not read to the accused person in a language that he understands, and he pleaded guilty, then that specific guilt plea will be set aside. Are you together? So if the court did not follow the procedure of recording a plea, which procedure is this? You must explain to the accused person in a language that he understands. The accused person must plead in person. The accused person should not be coerced to plead. The court must record the actual statements of the accused person in as far as possible using his own words. Whatever he said, that is what the court will record. It must be unequivocal. The plea must be unequivocal. It means unjustified than the one that is not justified. So those are the two instances, or the accused person was not represented by an advocate, and therefore he was not able to understand the seriousness of the plea that they took. So those are certain circumstances where you can come back and attack the plea of guilt. But unless you're challenging those two aspects, that is the process of taking the plea and the process of sentencing, that is the legality of the sentence, you cannot appeal against a plea of guilt. I hope that is okay. If that is clear, please give me some thumbs up so that I know. All right, so that is clear. The last thing before we get into the procedure is the question of bail pending appeal. Bail pending appeal. Now, the court that is sitting as an appellate court, or the court that is delivering the judgment, that is the trial court, at any time may admit the convicted person or the accused person to bail pending their appeal. Bail pending appeal, that is section 356. Okay, it says that the accused, the high court or the subordinate court which has convicted or sentenced a person may grant bail or may stay execution on a sentence or order pending the entering of an appeal. So you can apply for this bail pending appeal either at the magistrate court or you can apply for it in the high court, depending on the court that passed the judgment. That is the magistrate court, if in that case, or maybe the high court. And also, you can also go to the court that you're appealing to. Okay, that could be the high court in this instance. Okay, so please understand that that is bail pending appeal. So apart from those aspects, there's really nothing much about appeals. Let's just get straight into the procedure. The first one is appeals to the high court. Appeals to the high court. So what do you need to understand about appeals to the high court? Number one is the documentation. So what do you file in the court, sorry, when you're appealing to the high court? What is the first one? The first thing that you're going to file is the petition of appeal. Okay, the petition of appeal. The second thing is a copy of the judgment or order that you are appealing against. A copy of the judgment or a copy of the order that you are appealing against. Okay, so that is the question of documentation. Lastly is a question of timelines. So how long do you have to do all this? 14 days. 14 days. So let's go back up and talk about section 349, which has been read. So in terms of time limitation, an appeal shall be entered within 14 days of the date of the order, sentence, or order or sentence that you're appealing against. 14 days is all that you have. 14 days. Okay, but of course the court may extend this time. The court may extend this time based on the factors that you brought on board. So for instance, you are sick, you are not aware. There could be a lot of reasons why you are appealing way out of 14 days. But even in doing so, you must, and remember, you must give reasons why you're late. So it is 14 days, but if you are late, you have to give reasons, make an application and give reasons why you are late. So that is 14 days. The next thing is a petition of appeal. Let's see what a petition of appeals will look like in terms of what the law provides, and then we can see a quick draft of a petition of appeal. Okay, so 350 says that an appeal shall be made in the form of a petition in writing presented by the appellant or his advocate, and every petition shall, unless the High Court otherwise directs, be accompanied by a copy of the judgment or order that you're appealing against. So petition of appeal together with an order. Okay. Now remember, in civil, it is a memorandum of appeal and record of appeal. Now, in criminal, at this stage, when you're appealing to the High Court, you have, number one, a petition of appeal accompanied by a copy of the judgment, or a copy of the judgment, or a copy of the order that you're appealing against. Guys, are we together?
Yes, sir.
Yes, Mwalimu.
All right. The next thing that you need to understand is, after understanding the timeline, which is 14 days, you need to understand now the grounds. What are the grounds of appeal when it comes to petitions of appeal? What is the ground of appeal? The grounds of appeal, when it is a petition, it can either be a point of law or a point of fact. A point of law or a point of fact. What do I mean by that? What do I mean by that? Now, this is a first appeal. This is an appeal from the magistrate court to the High Court. It is a first appeal. And therefore, you know that first appeals, you can appeal on a question of law or on a question of fact. Are we together?
Yes, sir.
Yes, Mwalimu.
All right. So let's see what is special about petitions of appeal. What is special about petitions of appeal? Now, if you know how to draft a memorandum of appeal, that is the same way you draft a petition of appeal. That is the same way you draft a petition of appeal. The only difference is the name. Petition of appeal. Petition of appeal. So everything else is just the same thing. So let us try and edit this. So Republic of Kenya in the High Court. Because this is going to the High Court. Anytime you're appealing to the High Court, you do a petition of appeal in criminal, not in civil. In civil is a memorandum of appeal. So we are going to have here, let's say that person is our appellant. And then, of course, you know, the Republic is usually, okay, the Republic is usually our de facto respondent. So that is your petition of appeal. Let me correct something. Criminal appeal number that. All right. Now, the appellant being dissatisfied by. So here, when it comes to this specific place, you can either, okay, you can separate them or have both of them in the same place or just one. What do I mean? In criminal, there are two things. There's the judgment that comes as a conviction, and then there's the sentence. Those two things are separate. Okay. So you have to tell us whether you are dissatisfied by the judgment or the sentence. Okay. So you could say the appellant being dissatisfied by the judgment and sentence of the Honorable Magistrate dated the 20th of March 2019, hereby appeals to this court against the whole of the said judgment and sentence. Are you together? Now, what is the reason for that? Now, the reason is very simple. We have different items in criminal. We have judgment and sentence. They're different. Now, in civil, you'll just be saying the appellant being dissatisfied by the whole of the said judgment. Full stop. You don't have a sentence in civil. But when it comes to criminal, there are two things. There's the conviction, which is contained in the judgment, and then there is a sentence, which is separate. Are we together?
Yes, sir.
All right. So the appellant being dissatisfied by the judgment and sentence of the magistrate dated that day hereby appeals to this court against the whole of the said judgment and sentence on the following ground. So what are your grounds? What are your grounds? I have said the grounds could be a question of law or a question of fact. So how do you capture that? That the magistrate, sorry, this should not be a judge, and the magistrate erred in law and in fact by refusing to admit the evidence adduced by the appellant. Okay, so the question will give you what exactly is the issue with the judgment or the sentence. Okay, like the ones we saw, you're being told this person was not given the right to cross-examine. He was not given the opportunity, or the trial was conducted in a language that is foreign to him. So a lot of things. Any breach, you will come and say, the magistrate erred in law and in fact. Now that is supposed to cover you in an instance where the question you've made reference to is just a question of law or a question of fact only. So you just say made in law, or sorry, add in law and in fact. Okay. Guys,
We're together, Mwalimu.
guys, are we together in terms of drafting a petition of appeal?
Yes, we are.
We are together.
All right. So that is the petition of appeal. Now this document, you already captured the grounds. They could be as many as 10 or even just one. Then you come to the prayers. What are you praying for? Okay, the appeal be allowed. And then once the appeal has been allowed, remember, I'm editing this because we used it in civil. Okay. The judgment be quashed. Sentence is set aside. Like I've said, there's so many ways of saying whatever I'm typing. You can say the court be pleased to issue an order quashing the judgment. The court do issue an order setting aside the sentence. So there are so many ways of saying it. I'm just not saying it in that way, but you can say it in a lot of ways. Okay, and then that is your petition of appeal, and then dated at that time, the name of the advocate appearing for the appellant, drawn and filed by, to be served upon. This is the petition of appeal. It's a very simple document, a very, very simple document. Now in civil, we just remove the word petition and we write memorandum. It is the same thing. Even when we get to the Court of Appeal, it is still the same thing. All right, so look at your screen, have a moment with it, check that out. That is a petition of appeal. If there's a question, your hand should be up. If there's no question, let us go to the last bit of petition of appeal. So I've said petition of appeal is presented at the High Court and it is 14 days. Now in civil, you appeal through the memorandum of appeal together with the record of appeal, and it is 30 days. Now in criminal, we don't have 30 days anywhere. We don't have 30 days anywhere in criminal. We just have 14 days, 14 days, 14 days. Okay? All the timelines for appeals in criminal are 14 days. What do I mean? If you're going to appeal to the Court of Appeal, notice of appeal, 14 days in the High Court. Okay? And then memorandum of appeal is filed 14 days again after receiving the record of appeal. So it is just 14 days, 14 days, 14 days. So there's nothing to confuse you in criminal. In criminal, standard 14 days. In civil, it is 30 days, 14 days, 60 days. So don't confuse civil and criminal. No. Guys, are we together? So in criminal, 14 days, 14 days, 14 days. What do I mean? 14 days at the High Court, 14 days notice of appeal, 14 days memorandum of appeal in the Court of Appeal. Tunaelewana? Anybody confused?
Nobody.
Tunaelewana mwalimu.
Okay, so let us go and talk about, so this document is accompanied by a copy of the judgment. Okay, copy of the judgment. We don't have record of appeal here. It is just a copy of the judgment, just the copy of the judgment or the copy of the order that you want to appeal against. Now let us go and talk about appeals to the Court of Appeal. Appeals to the Court of to the Court of Appeal. When you are going to the Court of Appeal, what do you need to understand? The first thing is that there are two instances. Either you are appealing for the first time, that is from the High Court to the Court of Appeal for the first time. And these one are matters that were tried in the High Court, including murder, treason, and offenses under the ICL, Article 6 to Article 9 of the Rome Statute. Are you together? Now, what is the second one? When you are appealing for the second time, which is from the magistrate court, you appeal to the High Court. You are not happy still at the High Court, you go to the Court of Appeal for the second time. Now, what is the difference? Now, if it is a first appeal, then it is on a question of law and fact. If it is a second appeal, then it is only a question of law. Are you together? That is the appeals to the Court of Appeal. Now, what are the documentation when you're going to the Court of Appeal? The first one is notice of appeal. Okay? Notice of appeal. The notice of appeal is filed at the High Court, the Superior Court. I've said this before and I'm going to say it right again. The Superior Court is the High Court. If you are told that the judge of the Superior Court, made an order, okay? The judge of the Superior Court made an order, okay? Then you know it is the judge of the High Court. And therefore, if you're challenging that order, you need to go to the Court of Appeal, either on a first appeal or on a second appeal. Guys, are we together?
Kabisa, sir.
All right. Now, let us go to the documentation. So the first one is a notice of appeal that is filed at the High Court, that is the Superior Court, which is filed within 14 days. 14 days, notice of appeal. After you file your notice of appeal, the registrar of the High Court is supposed to prepare for you the record of appeal. Now, in this instance, the only record of appeal you'll be getting from the registrar is the typed proceedings. Okay, the record of appeal. So the registrar, as soon as possible, because that's the timeline given to them under the Court of Appeal rules. Let's just go there before we come back. Appeals in criminal are very easy. They're not complicated as that in, but appeals generally are just very simple. All right. You can see my screen. That is the Court of Appeals. Court of Appeal rules. Let us start from 58. So criminal appeals and review. So this part shall apply only to appeals from superior courts acting in their original and appellate jurisdiction in criminal cases and to matters related hereto or thereto. Okay. Number 2 is at section Rule 59. Rule 59. Now, Rule 59 talks about the first document that you need to file when you are going to appeal to the Court of Appeal, okay, which is a notice of appeal. Now, any person who desires to appeal to the court, that is the Court of Appeal, shall give notice in writing, which shall be lodged in a certificate with the registrar of the Superior Court at the place where the decision against which it is desired to appeal was given within 14 days. Let me just highlight that for you. Within 14 days of the date of that decision, and the notice shall institute the appeal. Are we together?
Yes, we are.
Yes.
All right, somebody explain this and why this is interesting. That is, the notice shall institute the appeal. Why do you think that is interesting? Why do you think that is important to note? Somebody? Jamal?
Yes, I think it's because in civil, a notice of appeal does not amount to an appeal by itself, but in criminal we see that the notice of appeal actually functions like an appeal.
Thank you very much. That is a point you need to understand. That is a point that you must understand. Okay. Now, you have to file your notice of appeal in the High Court within 14 days, and that notice will institute an appeal. The moment you lodge a notice of appeal in the High Court in criminal, that will be considered that you've lodged an appeal. Okay. That is clear. That is clear, and within 14 days. So notice of appeal, 14 days. Notice of appeal, 14 days. We are going to look at what a notice of appeal is supposed to provide, which of course, is the nature of the acquittal, conviction, or sentence that you are appealing against, whether it is a specific or the entire of it. And number two, the address of parties. Okay, the address of parties where you the documents will be served upon. Now, you have filed that specific notice of appeal. What next? Okay, let's go to 62. Okay, so you file a notice of appeal in the High Court. Okay, in the High Court within 14 days. What is the next thing that is supposed to happen? 62, preparation of a record of appeal. As soon as practicable, after a notice of appeal has been lodged, the registrar of the Superior Court, that is the High Court, shall prepare the record of appeal. So it means the record of appeal is supposed to come from the registrar. Now, there is a lot of challenges in terms of the registrar preparing a record of appeal for everyone. So in practice, you will prepare it yourself, but you wait for the typed proceedings. The registrar will only bring the typed proceedings, but the record itself you will make yourself, which of course will include the index of all documents that were filed, charge sheets or the information, the trial judge's notes, including the proceedings, the transcript of any shorthand notes taken by the at the trial, the list of exhibits that have been filed, all documentary exhibits, photographs, plans, so every single document that was filed in the trial court will form part of the record of appeal. Okay. Now, the timeline for preparing the record of appeal is not specified. It is only said as soon as practicable. Now, in civil, you have to file your record and memorandum within 60 days. Now, in this one, the record will come first, which is prepared by the registrar at any time they want. And then let us go to the memorandum of appeal under 64. Okay. Now, let me highlight it first before we read it. The appellant shall, within 14 days after service on him of the record of appeal, lodge a memorandum of appeal in that one with the registrar or with the deputy registrar at the place where the appeal is to be heard. Okay, so you lodge your memorandum of appeal once you have received the record of appeal. So if you receive the record of appeal today, you count 14 days, and within the 14 days, you must lodge your record of appeal and the memorandum of appeal. Are you together with the registrar of the Court of Appeal? Guys, are we together? Are we together?
Yes, sir. Yes, sir. Kabisa, sir. Kabisa.
So in criminal, it is 14 days when you're appealing to the High Court. Okay? When you're appealing to the Court of Appeal, it is 14 days. 14 days. The first 14 days is for notice of appeal, And then the second 14 day is after you receive the record of appeal, you have 14 days to file a memorandum of appeal. Now, what happens if you are supposed to, or if you receive the record of appeal late? Now, the registrar is supposed to give you certificate of delay. If the registrar is not able to get you the record of appeal in good time, they normally give you what we call a certificate of delay. Certificate of delay is supposed to inform the registrar of the Court of Appeal that the record of appeal from the High Court will delay, and therefore he or she is supposed to allow you to appeal as you wait for the record. That is a certificate of delay, to tell the Court of Appeal that we are still in the process of developing the record of appeal for this guy, and it will delay for a minute. That is a certificate of delay. So that is how you appeal to the Court of Appeal. So you know the documentation and you know the timelines. So what are the documentation? There are two major documents when you're going to the Court of Appeal. The first one is a notice of appeal that you prepare yourself. The second one is a memorandum of appeal that you prepare and lodge within 14 days after you receiving your record of appeal. Record of appeal is prepared by the registrar of the High Court, and it includes all the documents that we have mentioned. Guys, are we moving towards the same direction?
Yeah, kabisa.
All right, so let us go and look at what. Yes, Joy.
Just a quick clarification. So after you have received the order or the conviction, the order or the judgment, then I have 14 days from then to file the notice of appeal. And then after it's received by the registrar, they also have 14 days to for the record of appeal. That is a confusion.
Once judgment has been made by the High Court, once judgment has been made by the High Court, you have 14 days to lodge your notice of appeal. Okay. Once you not lodge the notice of appeal, you are simply telling the registrar of the High Court that, Hoya, I want to appeal to the Court of Appeal. Give me the record of appeal. The registrar will take his sweet time. Okay. You will sit at home until you receive the record of appeal. From the date you receive the record of appeal from the registrar, your 14 days will start counting, and then you're supposed to lodge your memorandum of appeal.
Okay, that's fine. But then what is considered a delay? Because you see, there's the certificate of delay that is
that is the registrar. The
yes,
registrar will determine.
Yeah, so what is considered as a delay?
That is the discretion of the registrar. If the registrar feels like there's a lot of backlog on their end, that they will not be able to give you that in good time according to them, they'll give you a certificate of delay.
Oh, okay. Because I think what I'm asking is how long should it take?
That's what I'm telling you. That's what I'm telling you, that will depend on them, because the Court of Appeal rules provide as soon as practicable. Okay? It does not provide what timeline you are supposed to get this record of appeal as soon as it is practicable. But it is the registrar of the High Court that will determine whether they are able to get you that in good time, which again, good time, it is them to determine. But also, the question of reasonability. They need to be reasonable. They cannot give you 1 year or what. Okay? But we've seen instances where it has taken 1 year to get a type proceeding from the High Court. It can take even 2 years. It depends on your lucky day. It could take a month. It could take 2 weeks. It depends on how easy it is. And some instances, people go there and you pay something small and you get your record of appeal and you move on with life. But sometimes it can take even a year. But if the registrar is of the opinion, and most of the time when what happens is, if you think your client's interest is being violated or is you need to move faster, then you apply for certificate of delay. You tell the registrar that I know you are busy, but as you keep taking your sweet time, give me a certificate of delay so that I can proceed on my end.
Okay. That makes sense. Thank you.
All right, Kimani, what is your question?
Can you hear me?
Yes, I can hear you.
Okay. Yeah, so I just wanted a quick clarification. When you were talking about the petition of appeal, you said like essentially it's like the same template as the memorandum of appeal for civil. So I was wondering whether in some certain memos of appeal for civil, it usually beneath the memo of appeal title usually says being an application on the judgment of this court given at this date on this time. So do you need to add that?
Where? What do you mean being an application? Memorandum of appeal is not an application.
Okay.
Memorandum of appeal is a pleading. If you're told to prepare a pleading, in fact, this is one of the general rules. If you find a question in criminal telling you to draft a pleading, there are only two things you could draft in that question. Number one is a petition of appeal. Number two is a memorandum of appeal. And in certain instances, a constitutional petition for judicial review. Those are the only times you will come across the question of pleadings in criminal. Petition of appeal is the first pleading you will be meeting. Okay. The second one is the memorandum of appeal. The third one is during judicial review, where sometimes you're told to prepare judicial review. That is the only instance you will be dealing with pleadings. Now, those are not applications. So this is a notice of appeal. This is the one you do in civil. It is the same thing you do in criminal, but let's go through it as we. Yes, Olubi, what is your question?
I just wanted a clarification on when you apply to the registrar of the High Court for a record of appeal, and they don't provide, and now maybe you get the certificate of delay. I understand the record of appeal is supposed to be coming the proceedings, what transpired at the High Court. So what I wanted to know, how will the Court of Appeal proceed in case you get just a certificate of delay without the proceedings at the High Court?
The certificate of delay is supposed to just to give you the opportunity to file your memorandum so that you can get a date at the Court of Appeal. It does not give you the opportunity to proceed. It just gives you a slot at the Court of Appeal because you can't file a memorandum of appeal without the record. You have to wait for the record and then 14 days you file. So when you get a certificate of delay, it only gives you the opportunity to file your memorandum of appeal for purposes of getting a slot in the court's calendar. But for us to proceed, we will still have to wait for the record from the court. Are you together?
Yeah, that's clear.
All right. So, sorry, took it out. Let me bring it up quickly. That is the notice of appeal. So this is the notice of appeal that you will do in criminal, of course. It will reflect the caption of the case at the High Court. At this time, you have not appealed.
Correct the captions. I mean, the captions should read in the Court of Appeal, I think.
No, it doesn't read in the Court of Appeal, Abdisalan. Where do you lodge the notice of appeal?
To the High Court.
The Superior Court, you're right.
The Superior Court. Now, let us talk about these two things. Let me highlight them for you. And let's see why they are the way they are. Your caption in as far as notice of appeal is concerned. Now, we have first appeals and second appeals. Okay? Now, in first appeals, let me just remove this one. Okay, so in second appeals, let's talk about second appeals. Or let's start with first appeals. So in the magistrate court, we had, let's say, let me just use your name kindly because I can't remember any other name. Let's say Olubi. Olubi was charged in the magistrate court and he was convicted, but he appealed to the High Court in the first appeal. So in the High Court, it was Olubi, the appellant from the Magistrate Court, versus the Republic, which is the respondent. Okay, the respondent in the Court of Appeal. I mean, in the High Court. Now, at the end of this case, two things can happen. Okay, the first thing that can happen is that Olubi can win the case at the High Court, and then it is now the Republic that is appealing, or Olubi can still lose at the Court of at the High Court, and then is the one still appealing. So if Olubi is the one still appealing, then we are going to have Olubi, the appellant, the same way it is, the caption that was there in the High Court will be like that as we do the notice of appeal. The appellant and the respondent. That notice has not changed. The second instance is this. Olubi was charged with murder. Murder is tried at the High Court. Okay? So in this instance, we are going to have the Republic versus Olubi in the High Court. Okay? Now, in this instance, the Republic is not the appellant because the Republic is still the what do you call it?
The respondent.
Oh,
The respondent.
No, we have the prosecutor
No,
being the
prosecutor.
Yes. The prosecution.
yes, we have the prosecution there.
And the accused.
Prosecution. And then we have the accused person here. Okay. The accused person. So this is murder trial in the High Court. Now, if you're going to do our notice of appeal to the Court of Appeal, sorry, to the High Court and appeal to the Court of Appeal, the caption will remain the same. Remember, in the first instance, it was Olubi, the appellant, versus the Republic, the respondent. Why was that the case? Because it was an appeal already from the Magistrate Court. Okay. Now, in this instance, this is the first time that we are going to appeal. This matter was filed before the High Court. So the Republic was the prosecution, and then Olubi was the accused person. Are you together? Now, in this instance, if Olubi is the one appealing, then we are going to come and say, take notice that the accused person let me just have that. 1 minute. All right. So take notice that the accused person being dissatisfied with the judgment and sentence. Okay. Of this dated dated 11th May 2024 intends to appeal to the Court of Appeal against the whole of the said judgment and sentence. Okay, so take notice that the accused person being dissatisfied, that is the notice. The accused person is the one giving notice. Or take notice that the prosecution being dissatisfied. Guys, are we together?
Yes, we are.
All right. Now, when you're going to do your memorandum of appeal, now the parties will change. Now we are going to have the appellant and the respondent. depending on who is applying. So for instance, take notice that the accused person, okay, that is in the notice of appeal, this is the accused person who is intending to appeal. Now, in our memorandum of appeal, it will be the same accused person, but now is called the appellant. Okay, it's now called the appellant. That is the right way to prepare this. But if it gets to the 12th feet, okay, the 12 feet where you can't, you're not able to refer it back into who is who and what, even in your notice of appeal, just have the appellant and the respondent. For instance, in this case, if our Olubi is the one appealing, if this was the caption and Olubi is the one appealing, just have Olubi there being the appellant, and then the prosecution being the respondent, So that is prosecution. So if you don't want to go through the trouble of making it make sense in terms of the parties and all that, just have who is the appellant and who is the respondent. Just ask yourself in this question, who is appealing? Okay, that person who is appealing will become the appellant, and who is responding? The person who is responding will become the respondent. And then you come to the notice and say, take notice that the appellant, for instance, in our case, the appellant is Olubi. The appellant being dissatisfied with the judgment and sentence. Okay, this is very, very important. Judgment and sentence of this honorable court dated that day, intends to appeal to the Court of Appeal, okay, against the whole of the said judgment and sentence. Now, sometimes you are just challenging the sentence. Being dissatisfied with the sentence of this honorable court intends to appeal to the Court of Appeal against the whole of the said sentence or against the said sentence. So remember, when you challenge the judgment, you also challenge the sentence. But you can challenge the sentence without challenging the judgment. So look at the question. What is your client saying? Is this challenging the sentence alone, or is also challenging the judgment? If they're challenging the judgment, which is the conviction, then it means they're saying they are innocent. And therefore, if they're claiming to be innocent, then they're also challenging the sentence. I don't know whether I'm confusing you more or you're getting that. What I'm saying is you can challenge the sentence alone. It is only the sentence that can stand alone, but the judgment must go with the sentence. Unaelewana?
Kabisa, because like in the summary judgment, you only challenge the sentence.
What do you mean summary judgment and summary sentence? Are you okay?
Where the accused did not raise a defense.
Hiyo umesikia wapi? Kijana, I've told you all the time, please. Wacha kuonja hizo vitu zako. Not safe. Who told you that if the accused person does not raise a defense, there's a summary judgment? There's no summary judgment in criminal. There is no summary judgment in civil, in criminal. Are you together?
Okay, what happens when the accused pleads guilty?
Then there is no judgment. When you plead guilty, there's no judgment. It is sentence. You're convicted, pap, and you're sentenced. There's no judgment when it comes to plea of guilt. Because what is judgment? Judgment is us judging two sides, the prosecution and the accused person, who is saying the truth, and then you write a judgment. Now, when you say you're guilty from the first onset, we don't need to go through judgment. There's no judgment in that. We just convict you, and then we sentence you. Are you together? So there's no summary. When you call it summary judgment, you lose the entire point.
I have no text. So it is in the sentence without the judgment where in such scenario you can only now challenge the sentence, but there was no judgment.
You're going to confuse yourself and confuse a lot of people. So just understand, you can challenge a sentence alone without challenging the conviction. For instance, in the instance where you pleaded guilty, you can do a notice of appeal or a memorandum of appeal challenging just the sentence, being dissatisfied with the sentence, or even here where there's a judgment, you are going through the judgment and you're like, no, I think I'm guilty, but this sentence is harsh. You just challenge the sentence. Okay, but in most instances, people challenge both judgment and sentence, but that depends. All right, so guys, are we together in terms of what notice of appeal will look like? So just give us what you're appealing against, and then give us the address of service of parties, which is the address of service of the appellant will be that, and then the address of service of the respondent in this instance will be the prosecutor. So what is the prosecutor's address? So we are going to have the prosecutor there, which is the ODPP, the Office of the Director of Public Prosecution. Your box that you'll find the address if you're given the question. All right, so that is the notice of appeal. It is lodged in the High Court within 14 days after the judgment or the sentence that you're challenging. Yes, Alingo.
Mwalimu,
Quickly,
a
guys.
question. A question.
Yes.
We are lodging a notice of appeal. We are appealing for the second time to the Court of Appeal, but first we are putting a notice of appeal to the High Court. Now, Mwalimu, if, for example, the High Court upheld the sentence that was issued in the Magistrates Court, is there like if it is upholding the sentence, is there a document that they are signing showing that it is upholding, or they just make an oral statement?
Who makes an oral statement?
Okay, like the judge in the High Court, now in his judgment, he says that subject to the appeal from the Magistrates Court, he's upholding the conviction and the sentence of the accused person.
And he will say that orally. Wait, because what you're asking is extremely ridiculous. He will say that orally, that as a judge, he will be sitting there, and then as a judge, I'll say, in my judgment, I think the Magistrate Court said they did the right thing. I've upheld the finding, and then he will go away.
Okay. Apologies for that. Let me rephrase it. If he's going to make a judgment, aren't we going to say here that take notice that the appellant being dissatisfied with the judgment and sentence? Should we say judgment and sentence from the High Court? Because now, if it
but
is just
of
like
this
that,
honorable court, which court are we before?
oh yes, the High Court, Sorry
There's no
about
notice
that.
of appeal. There is no notice of appeal from the Magistrate Court. We don't have notice of appeal in the Magistrate Court. We just have notice of appeal in the High Court. So you are telling the court that I'm dissatisfied with your judgment. Judgment must always be in writing. There's no oral judgments.
Yes.
Okay. Alphonse, quickly.
Yes. Yeah. Thank you.
All right.
Yes, Mwalimu, I have a question where it's a second instance appeal. That is, it came from the Magistrates Court, and now our appellant is the prosecution at the High Court. The person who is appealing is the prosecution. So in such a case, I presume that we are supposed to retain the caption as it was in the High Court. That is, Olubi will still be the appellant, and the prosecution will be the respondent. Now, if you come into the contents of the notice of appeal, at the second paragraph, or even at the starting instance, will we be referring to them as the appellant or as the respondent?
Yes, just say the respondent.
The respondent.
The respondent being dissatisfied with the judgment. So the respondent is not the respondent for the Court of Appeal? The respondent is, when the court goes through that, they will know that the respondent in the High Court was the prosecution, and that prosecution is dissatisfied. You could say the prosecution being dissatisfied or the respondent, because at the High Court, they were the respondent. So you can just say the respondent being dissatisfied. Okay?
Okay, that is clear. I'd presume that this appellant refers to the appellant who is now appealing to the Court of Appeal, but it's now clear. Thank you.
Yes, and that's what I said, that if you are not able to tie the dots of which party is which, then the easiest way out of it is just ask yourself, in this question that we've been given, okay, before asking yourself, who are the parties here? How did they appeal? How are they called from the magistrate court? No, just ask yourself from the question, who is appealing to the Court of Appeal? It is the prosecution. That becomes the appellant versus who? This person. You get what I'm saying?
Yes, yes, yes.
Yeah, so either you write, whether you write it like this or the other way around, you still get the marks, because remember again, a notice of appeal will already be considered as an appeal because it lodges an appeal in the Court of Appeal, in criminal as well. You just ask yourself, who is appealing? Who is responding? Then give us a notice of appeal.
Okay, thank you.
All right. There's no further questions. So let us look at quickly the memorandum of appeal that we are going to file in the Court of Appeal. So the memorandum of appeal must have the caption of the Court of Appeal. My screen is up. Remember, we said that the petition of appeal is the same as the memorandum of appeal. And the same thing. The only difference is the name. Okay? The only difference is the name. And I explained to you why this one is called whereas they're the same document, but one is called a petition and one is called a memorandum. Okay? I explained that. And that has everything to do with the colonial judges that used to sit in the High Court and the African judges that used to sit in the magistrate. So if you are going before the High Court, they wanted you to petition the High Court. Some kind of superiority was right there. So there's no difference between the petition and the memorandum. The only thing you change here is the name. Just say memorandum. Okay? Memorandum of appeal. Okay? Now, in your memorandum of appeal, the same thing. In the Court of Appeal, because remember now we are in the Court of Appeal, in the Court of Appeal. Okay? Memorandum of appeal, we have the parties there, the appellant versus the respondent. And take notice, there's no notice here, just say the appellant being dissatisfied by the judgment and the sentence of the honorable judge, not a magistrate. Remember now we are in the High Court. We are appealing to the Court of Appeal now. Dissatisfied judgment and sentence of, we say, of the High Court dated we will say of the High Court dated that day, 20th of March 2019, hereby appeals to this court against the whole of the said judgment and sentence on the following grounds. Or you could say, being dissatisfied with the judgment and sentence of the honorable judge. If you're given the name, you could mention the name. You could mention the name of the judge. Okay, so there's various ways you can say that. You don't need to say it in a specific way. So what are your grounds? That the judge, okay, in the petition, the magistrate. Here, the judge. The judge add in law and in fact. The judge add in law and in fact. Okay, are we guys together up to that point?
Yes, sir.
Yes, we are. Joy?
My question pertains to that very line. Since it's the Court of Appeal, should we really say in law and in fact, because it's only on the matter of law, a point of law?
That is what I'm going to explain next. Okay. So remember, not all the times you appeal to the Court of Appeal is a question of law only. Now, if it was a first appeal, what is a first appeal before the Court of Appeal? Joy, tell me, which was the first appeal before the Court of Appeal?
From the High Court?
Give me an instance where, give me an offense that will be a first appeal before the Court of Appeal.
Murder.
Why?
Because a capital offense. No, I'm not sure why.
No, you have to answer that question. We will not proceed until you answer. Which offense? Give me one offense that will be appealed to the Court of Appeal as a first appeal.
Rome Statute.
Okay, whichever. There's no offense called Rome Statute.
Okay. Crime against humanity.
Crime against humanity, fine. Why is that?
Because it's only convicted at the point of the High Court. And that's
so why did you change your mind on murder?
I just got nervous, but it's the same thing.
Yes. So offenses that are tried at the High Court for the first time, you appeal them as a first appeal in the Court of Appeal. And when it is a first appeal, you can have add in law and in fact. Add in law and in fact. However, if this is a second appeal, that is appeal that is coming from the magistrate court to the High Court, from the High Court to the Court of Appeal, then you can only say add in law. Add in law. Are we together?
Yes, we are. Thank you.
All right.
Yes, sir.
And then you come and give us your reason. So the question where the magistrate or the judge add in law will be in the question. Utaipata kwa swali hapo. Okay? It will be in the question. Whatever the question was saying, whether this person was denied the right to examine or do something, that will be in the question. And then what are your prayers? The first prayer is that the appeal be allowed, the conviction be quashed if you're challenging the conviction, the sentence be set aside, and then the cost of the appeal, and then any other relief that the court may order. Okay, so that is simple. So when you say the conviction be set aside, essentially you are like somebody saying the accused person be acquitted. Okay, that is exactly what you're saying. So it's the same thing. When conviction is set aside, then it means you've been acquitted. All right, so that is the prayer, dated and signed, to be served upon, of course, to be drawn and filed by you as the advocate of the appellant, to be served upon either the prosecution, or if you're the prosecutor here, it will be served upon the advocate of the accused person. Guys, are we together?
Kabisa, sir.
Yes.
All right.
Together.
Powers of the Court of Appeal. The first power of the Court of Appeal is to hear the matter or determine the matter conclusively, decide the matter finally. That is, the court will proceed and hear the matter and give its judgment, disposing the matter. That is the first power of the Court of Appeal or any appellate court. The second one is to remand. The court can remand the matter back to the trial court. Okay, asking this only happens in an instance where the court tried the question on irrelevant points. The trial court considered irrelevant points. So the case will be remanded back to them. Okay. The third one, the Court of Appeal or the appellate court, there are two appellate courts, the High Court and the Court of Appeal. They can frame the issues for determination. They can frame the issues for determination. Frame the issues for determination. The fourth one, they can order a new trial. Order a new trial. that this matter be tried again by a different bench of the High Court or a different bench of the magistrate, new trial. Okay. The fifth power of the High Court or the Court of Appeal sitting as an appellate court is to take additional evidence. Take additional evidence. The power to take additional evidence. They can take additional evidence. What are the conditions of taking this additional evidence? The first one, it must be a new evidence. New evidence. What is the threshold of new? It was evidence that was not available during the trial. That is new evidence. Number two, they have this evidence must be important. Okay, must be important. For instance, if you're coming to say that the accused person is married now, that is the new evidence you're bringing. Fine, it is new because when the accused person was convicted, he was not married. So the question of marriage is new. Okay, but how important is that in this case? It must be important. How do you test importance? If it is capable of changing the outcome of the case. Okay, then that is, or changing the sentence. So for instance, if you're saying that this person was sentenced to life imprisonment because he was single, you know, some people have been single for a long time. They need to be sentenced to life. You know, they need to go get their soulmates in prison. No, maybe your soulmate is in prison and you're just here chilling outside. Your soulmate is serving life imprisonment and you're here waiting for them. You need to go join them there, you know. So if that was a case, if there's a law like that, then you could say, Your Honor, now my client is now married, so don't send him send him to prison for life. He's now married. That would be important because that would change or sway the decision of the court. So it must be new, must be important. Number three, it must be an evidence that is capable of being admissible. Okay, must be an admissible evidence. It is not something that cannot be admitted before the court. There's some evidence that cannot be admitted before the court. So it must be admissible evidence. Lastly is the question of how is this evidence taken? Through examination of parties, examination of witnesses, affidavit, or the court can order a trial court to take the evidence for it, or the court can order any magistrate to take the evidence for it. That is the end of appeals. 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 Questions as we go to trial quickly. I'm trying so that we are able to finish criminal and start past papers in the next class. Okay? In the next class, we will start past papers. So we shall have 2 classes this week for criminal alone. That is on Saturday and today we have criminal. On Saturday, we'll be able to do all the remaining topics. Things like, I want us to do habeas corpus today. I don't know whether it will be possible to do habeas corpus today, but if it is not possible, we'll do habeas corpus in the next class, as well as questions to do with extradition, as well as private prosecutions and inquest. And then the tribunals and the specialized courts, we shall do them as we revise the past papers. All right, that is okay with everyone. Give me a thumbs up if you're okay with that. All right, so let's talk about the last one, the last remedies against judgment, the last remedy against judgment, and that one we are calling retrial. Now, this is where we are opening a document that some of you have never opened. Let me open it for you. For the first time, you'll be seeing it and you're like, wow, this is how it looks like, you know? Some of you have never opened this document. I know that person is Kamiri. Kamiri has never opened this document. Have you?
Of course, not once.
I know you have 2 copies of them, but you don't open. This is the Constitution of Kenya 2010. Some of you don't open this document, by the way. It's not even a joke. Sadly. All right, so the Constitution of Kenya 2010 comes up there. As I do this, there are two questions. There's a question in 2018 or 17. Okay, it's a question 6. Is a question 6. That question says that somebody, is it 2018 or 2019? One of the papers. What is the name of this guy? Somebody died. Somebody was convicted of killing someone, and after they died, or after some time, they were, of course, they're sent to prison, and then after a few months, this person was or resurrected, whatever. He came back home. The person that allegedly was killed now came back. There's a question like that. It's called the same question that question 5 talks about boss. Then question 6 talks about that person. Please send it to me right now. And also 2021 June question 5. I will use it to explain this point. Let's go to Article 56. Article 56. Let me bring up my screen. Uh, 56 right there. And that is the Grundnorm, the Constitution of Kenya 2010. This is how it looks like for those who've never seen it. All right. So I will give the context. I will give the historical context first, and then we are going to discuss it. Now, you guys know very well. You've heard of cases whereby somebody has been framed and taken to prison, and then few months after being in prison, or within some years, evidence comes up that this person actually didn't commit the offense. And the latest one you've seen, I think there's one in Eldoret, should be Eldoret. In the last month, there's been a man that was acquitted just because the wife colluded with the daughter. But aside from that, there's the one, the famous one in Machakos, where Dunga J delivered a ruling in this instance that the guy went to prison because allegedly he had assaulted sexually the daughter. I think after 1 year, the daughter came clean and said the father didn't assault her. It was actually the mother that colluded with her to say that. Now, in that instance, turns out that the father is innocent. Now, what is supposed to happen if that was your client? He went to prison for a wrong offense. He's been there for 2 years. Okay, he's been there for 2 years. And then it comes out, turns out that he's innocent. How are you supposed to address that? Do you appeal? Do you apply for revision? What do you do? Okay. If there's new evidence that has come up, what do you do? That is the first one. The second thing is, in civil, we have Order 45 in civil, provides for appeal, for review. Now, that thing that you're calling review in civil, here in criminal, it is called a retrial or a new trial. Okay? Now, in civil, there must be new and compelling evidence. Okay? Now, in criminal, where there's new and compelling evidence, we do what? We do a retrial, don't do a review. Guys, tuko chonjo mpaka hapo? Tunaelewana?
Yes.
Yes, sir.
All right. Now, let us answer question. Sorry, let us address Article 50, sub-article 6. That is what is on the screen. 56. 56. Somebody read.
A person who is convicted of a criminal offense may petition to the High Court for a new trial if A, the person's appeal, if any.
Hey, start
6.
with read 6 and read B and then read A.
Okay. A person who is convicted of a criminal offense may petition the High Court for a new trial if B. New and compelling evidence has become available. A. The person's appeal, if any, has been dismissed by the highest court to which the person is entitled to appeal, or the person did not appeal within the time allowed for appeal.
Yes. Okay. So that is what you're calling a new trial. Now, in this instance, we're saying if you have been convicted of a criminal offense and then sometime later you find out, okay, sometime later you find out that you are actually innocent, new evidence has come up, new evidence has just been discovered, then you can only apply for a new trial if A, your appeal has been dismissed by the highest court you could have appealed to. That is the Court of Appeal. I keep saying the Court of Appeal is the court of last resort. You cannot appeal further than the Court of Appeal. Okay? When you're challenging your guilt or challenging your innocence, whatever, you cannot pass the Court of Appeal. That is the last place you can say that. The Supreme Court doesn't convict people or acquit people. The Supreme Court only determines constitutional questions. So if you have a constitutional question that you've discovered in your criminal trial, that is when you can go to the Supreme Court. But other than that, all criminal trials will end at the Court of Appeal. Are we together? Now, if you had appealed until the Court of Appeal and your appeal was thrown out, and then 2 weeks later, there is new evidence that has come up, you will proceed and get a new trial. Number one. Number two, if you have not appealed, new evidence has come up and you did not appeal in good time. Why? You are convicted, you just went to jail, you didn't appeal. You've taken 1 year in prison. It means you can't appeal now because the time for appeal is over. That only gives you one option, which is new trial. So for there to be a new trial or what we call a retrial, then there must be new evidence which is coming up at a time when you can't appeal. Now, this is the logic. We have talked about the powers of the Court of Appeal, right? And we have said one of the powers of the Court of Appeal is to take what we call additional evidence. New evidence can be taken at the Court of Appeal. It means if you are appealing, either the High Court or the Court of Appeal, the appellate court can take additional evidence. It means if you have been convicted today and then tomorrow you find new evidence, you don't go and apply for a trial. Just appeal and then adduce that new evidence. Appeal on the strength of new evidence. Appeal to the Court of Appeal or to the High Court and tell the High Court, I have new evidence that I've just discovered right now after being convicted. Then that is appeal. But in an instance where you can't appeal, why can't you appeal? You already appealed some time back, it was thrown out. Number two, the time for appeal is over. The only remedy available for you is to move the court for a retrial. Okay? Now, which court are you moving? The High Court. How are you moving the High Court? Two things to know. 56 provides for petition. You petition the High Court. Petition the High Court. Okay? You petition the High Court. Now, the word petition doesn't mean you do a constitutional petition. It doesn't mean you do a constitutional petition, that you do an actual petition to the High Court. It simply means you move the High Court. Okay? You move the High Court. Now, that application or that specific moving the High Court is done through an application. It is a notice of motion application and a supporting affidavit. However, in practice, you will come across people that do the petition itself and the supporting affidavit, also people that do the notice of motion application. Okay, both in practice. Now, in an exam, the easiest way to go around this thing is to do a notice of motion. You can still do a petition, but I would advise you to do a notice of motion. Guys, are we together?
Yes, we are.
So do a notice of motion, and some questions will clearly tell you that proceed and prepare the application. You proceed and prepare the notice of motion. Okay, some questions will tell you proceed and draft the relevant pleadings. Still do the notice of motion. I will explain by 3 questions. Somebody is trying to send me that question, but is not sending. Please don't send a screenshot. I need to project that question. So don't send a screenshot. Just send me the question. But as you send, let me, there's a question in 2022 November, October. Should be October. 2022 October or November, October, yes. And then 2021 June. Let me bring the 2021 June question. So I want to explain it better using a question so that you know what I'm talking about instead of theory. If you have a question, just ask. I'm still tracing down the June 2021. June 2021. Yes, there it is. So the question 1 for 2023. Please send it to me right now. Let's go to June 2021, question 4, question 5. Actually, question 2, not question 5. Sorry. Somebody read it. June 2021, question 2. Question 2A. Somebody read it if you can see my screen.
Question 2. Of course, the question itself is to draft the necessary application. Let me read. Sibalao was charged with the offense of stealing by servant contrary to section 251 of the Penal Code. He was charged, convicted of the offense, and sentenced to 5 years imprisonment. The charge and the conviction were based on the testimony of the workmate, Corinne's mate, Corinne's mate, who reported to the police that Simbalao had stolen a laptop. After serving a year in jail, Corinne's mate went to the police station and reported that he had provided false information which led to the conviction of Simbalao, and that Simbalao did not steal the laptop. He produced evidence of audio recordings he had with another colleague with whom they had a plan to terminate Simbalao, knowingly very well that Simbalao did not steal the said laptop. The police in turn advised Corinne's mate to present the evidence to Simbalao and apologize. Simbalao accepted the apology. Simbalao has, however, instructed you to proceed and have his sentence set aside and conviction quashed in the view of the new evidence from Collins Marte that he did not commit the offense of stealing by servant, where he reported that he had provided false information which led to the conviction of Simbalau. So draft the necessary application.
Yes. So in that instance, you can see clearly that this person has been accused of stealing after going to jail in 1 year. For 1 year. A friend comes and reports that actually that was a plan, that was not true. He didn't actually steal the laptop. Okay. Now with this new evidence, what are you supposed to do? Are we together? Somebody tell me, what are we supposed to be doing here? What application are we drafting? Pandy Willis?
Yeah, with this application one, we will take notice that the requirement period for appeal has lapsed, which is 14 days. And therefore, he needs to appeal, but before he appeals, he needs to seek for permission for extension of time, so that.
Hey, let's stop there, my friend. Don't make no further point. Jurisdiction is everything. Without it, you shall not make further steps. Guys, what are we talking about here? I've just explained it here. And explain to me as I've already explained it. Alphonse, what is the question here?
Yes, Malim, I believe that we are supposed to be making an application for a retrial or a new trial in accordance with Article 56 of the Constitution, which states that if the window for appeal has already been closed, for instance, in this case, he has already served an year in jail, then it means that he cannot appeal, and new and compelling evidence becomes available. Then the option that is available to us is a new trial or a retrial.
Yes. So in this instance, you just do a notice of motion application and the supporting affidavit to this specific court. Okay. You do it to court. And then what are you praying for? Okay. What are you praying for? Before we get even further, I just wanted to give you that picture of what that question will look like before we look at the 2023 paper and the 2018 paper. What are you praying for now? So you do a notice of motion application and a supporting affidavit. So what is your first prayer? Okay. What is your first prayer? Nyangal?
To be granted leave to appeal for the retrial out of time.
No, guys. You can't appeal. You don't want to appeal. These people are not appealing. Guys, we have said there are 3 remedies. The first remedy is revision. The second remedy is appeal. Now, is revision available here? No, it is not. Is appeal available here? No, it is not. Okay? Let us go to the third one, which is a retrial. So this is a remedy of retrial, which is available in that instance where you can't appeal and there's new evidence. When do you do a retrial? There's new evidence that you can't appeal. So you are not applying to appeal out of time. No, you are doing an entirely different process, which is an application for retrial. You get an order of retrial from court to reopen the file and retry the matter in light of the new evidence. Number 2, you pray for bail pending that retrial. And then number 3, you pray for cost. Okay? Guys, I said the name of the application is the main prayer. So our application is an application for retrial. So the first prayer would be the court do issue an order of retrial or the court do issue an order directing the trial court, okay, directing the trial court to reopen the file and retry it in light of the new available evidence. Number 2, you pray for bail, and then number 3, you pray for court. So let me explain why. Okay, when you've been convicted, guys, and sent to prison, that is final. That order is final. Even if there's new evidence that has come up and the judge that convicted you was watching the television and have seen this new evidence, he cannot just come and release you from prison. Even you yourself, you can't walk out of prison and tell the people there that, hey, you've seen what has happened to me, let me go. Can't happen. You have to move the court to reopen that file because it was already closed. You have to move the court to reopen that file to retry it. So there must be a retrial based on the new evidence. Are you together? This matter must be retried again. This new evidence doesn't mean that you are innocent. No, it doesn't mean you are innocent. It could say you are innocent, but until the court tries it, you are still guilty. So you ask the court to reopen the file and try it again. Okay? Why are we calling it retrial? Retrial simply means let us go back and retry it. Okay? That is what retrial means. Let us go back and try the matter again. That is why it is called new trial. So it means we go back to the same court that convicted you and we adduce this new evidence before the court. Once the court has reopened the matter, the court will slot it for a hearing date. For instance, the court will say this matter will be heard on November 16th. Are we together? November 16th. And then you will appear before the court with the new evidence. The court will look at it, parties will be questioned, evidence will be adduced, and then the court will make a ruling, either setting aside your sentence and quashing your conviction, or the court will make a ruling that that evidence is not admissible. You go back to prison. Are you together? So it doesn't mean you are innocent, you're just going to walk. No, you must reopen the file and retry the matter, adduce the new evidence. The court will make a ruling whether your sentence will stand or it will be quashed. So what are you praying for first? The court do issue an order, or the court to direct the trial court to reopen the file and retry it based on the available new evidence. Okay? Number 2, because your client is, why is the person calling me now? Jesus. Because your client is in prison, you need to secure their freedom as they attend this retrial. So you pray for bail pending retrial. Okay? And then you pray for cost. Are you together? You pray for cost. That is all you need to pray for. Notice of motion, you pray for an order reopening the file to retry it based on the new evidence. Number 2, bail pending. That pending the hearing and determination of the retrial, the court do admit the accused person to bail pending retrial, or to bail. And then you pray for cost. And then you go to your supporting affidavit or your grounds. Your grounds are just these ones. That your client was, a summary of that, not everything. Your client was charged after spending 1 year in jail. Colleagues Mate has testified, has confessed that they hatched a plan to falsely incriminate your client. That is all, and that is all you are going to include in your supporting affidavit. Guys, are we properly clear on that point?
Yes, we are.
Yes, ma'am.
Yes, we
We are
are.
clear?
We are.
All right. Let me put up this question. Can you see the question? Joy, ask your question.
My question is relating to a situation where, let's say, you're already at second appeal and you are now at the Court of Appeal, and then there's new evidence that has been adduced. Do you still how does that work out? Do I stay the appeal? Does the appeal continue and I then do the application to
Joy.
the trial?
Joy.
Let's say
Joy. What have I said is the powers? What are one of the powers of the Court of Appeal?
Order retrial.
Leave alone that, guys. That there's a difference between this retrial and the one in the Court of Appeal. Very, very different. This is done by the High Court alone. But what did I say is one of the powers of the appellate court? Joy, we are still on you. Time. Joy, please speak up. Time is not on our side. You can't say you're not sure. We just spoke about them right now in this class, some 20 minutes ago. What are the powers of the Court of Appeal? Number one. Pick somebody else.
Epic Owino.
Owino, please, quickly, time.
Yes, the one that we are concerned with is the power to admit new evidence.
The power to take additional evidence. Now, I have said, guys, that if this evidence that you have that is new, you are finding it at a time when you can still bring it before the Court of Appeal or before the appellate court, you don't need to apply for a trial. Okay? You can only apply for a trial when you don't have the right of appeal. Why? Your appeal was thrown out or the time for appeal is closed. That is the only time you can bring in an application for a trial. But if this new evidence is coming up when you're ready before the Court of Appeal, you're appealing, just make an application. Tell the court, Your Honor, I have new evidence. And then the Court of Appeal will consider it and will make a ruling. So it will make a judgment based on that new evidence. Now for this one, this retrial, this is a totally different water. Okay? You already appealed. Appeal ikaisha. Tukafunga file, tukapeleka archives. Wewe ukaenda jela. Umekaa jela 1 year. So what that means is you can't appeal anymore because your appeal was thrown, your case was closed. Or ulienda jela, you didn't appeal, 1 year imepita, you can't appeal. You can only appeal within 14 days. You can't appeal. Now, based on that, because you don't have any avenue of redress, the only way you are given under the Constitution is to go back to the court, the superior court, the high court, and tell the high court that, look, I was convicted. I appealed up to the Court of Appeal. My appeal was thrown out. My file was closed. But as I speak today, I have new evidence. How can you help me, the High Court? The High Court is the one that has the power to order the trial court that tried you to reopen that file and try you again. Okay? The only time that that file can be opened for you to be retried again is when you go to the High Court under Article 50, Sub-Article 6, where there is new evidence that has come up at a time when you can't appeal. So if this new evidence comes up in 2 instances I've said, number one, it is coming up when you can still appeal, then go and appeal. Okay? When it is coming up when you are still in the process of appealing, proceed and appeal with it, because the appellate court has the duty and the power to take additional evidence. But this special retrial that I'm talking about is a special case. It only happens in the instance where you have new evidence, when you can't appeal, when you're not appealing. Okay? And that is where you shall proceed and do what? Make an application to the High Court. It doesn't matter whether you had appealed to the Court of Appeal. The High Court will still have jurisdiction to direct the trial court. The trial court can be the High Court itself or the Magistrate Court. There are only 2 trial courts, the Magistrate Court or the High Court. It is either your matter was tried in the Magistrate Court or it was tried in the High Court. If it was tried in the High Court, you go to that High Court that tried you and you ask them to reopen the file. If it was tried in the magistrate court, you go to the High Court and ask the High Court to direct the magistrate to reopen that file. Okay? I'm sounding like a pastor. Are we guys together?
Sorry. Just one more clarification. I do understand that the Court of Appeal has the power for a person to adduce more evidence, but does this also apply even if it's on second appeal? Because I thought that only applied to
the Court of Appeal. Listen, the Court of Appeal, anytime the court is entertaining an appeal, whether it is first or fifth or 20th appeal, while that matter is still before the court can still take additional evidence. So long as you have the ground, the first ground, it must be new evidence. It was not there during the previous proceedings, and it is an important evidence, then the court will still take it. Whether it is a first or a second appeal, it will still be taken. If you have the grounds, it will still be taken.
Okay, that's clear. Thank you.
Oh, question 2. Somebody read it quickly. Somebody's having a question. Samora, what is your question? Actually, I'm not taking any further question. Let's go to question 2, and then we can take further questions when we complete. Because of time, it's already 8 minutes past the time. Question 2, somebody read quickly.
Let me read.
In
In 2018, PM, who was 14 years.
Somebody, one person, please.
In 2018, PM, who was 14 years old, testified that she had been defiled by her uncle Timmy, who had forced himself on her when she went to visit him. On the strength of this testimony, Timmy was convicted of defilement and sentenced to 20 years imprisonment. Timmy unsuccessfully appealed to the High Court and did not pursue the matter any further. The High Court dismissed his appeal in January 2022. Timmy's family has now approached you to inform you that PM has since retracted her testimony and claims that she was coerced to testify against her uncle, Timmy, by her father, who had a land dispute with Timmy. PM, who is now 19 years old, has come to your office and confirmed that the testimony she gave at Timmy's trial was false and instigated by a father who had threatened to throw her out of his home if she refused to do as he asked. She further informs you that she has now decided to come forward and tell the truth since she no longer faces the threat of being thrown out of her home as her father recently passed on. Timmy's family has asked you to take the necessary legal action to secure his freedom. Draft the appropriate pleadings.
Yes. What are we talking about here? Somebody who has not spoken today, please complete for us. Finish for us so that we can proceed and do something else. Let's talk to Odur Nancy. What are we talking about here?
Hi, Mwalimu. We are talking about a retrial.
So what do we do?
So we make an application to the High Court.
That answer is very incomplete. Somebody give me a full answer. Pande Willis.
Yeah, this is a retrial from the High Court. You make an application for petition for a new retrial.
There's nothing like new retrial, my friend.
Trial on the case.
What are you petition? What are you applying for?
You are applying for a petition for a retrial.
What are you saying?
You have found a new and compelling evidence, and you now need the court to order the matter to be tried afresh. So your
what are you applying for? What are you applying for? What are you applying for?
For a retrial.
Yes, just say you're applying for it. When you say you're applying for a petition for a retrial. Doesn't make sense. So you're applying for a retrial.
Yes.
What is your first prayer? Which first? Where?
The High Court.
The High Court.
The High Court, yes.
What are the prayers?
The prayer number 1, that you have found new and compelling evidence.
Where? Don't try me. How is that a prayer?
The first prayer is to order for the retrial, directing the trial court to reopen the case and retry.
Who is speaking? I can't hear anyone. Who is speaking?
The retrial. The first prayer is to order for retrial.
Who is speaking? Who is speaking, please?
Joy.
Okay, proceed. What is the first prayer?
The first prayer is to order requesting for that the High Court orders the trial court to reopen and retry the case.
To reopen and reopen what?
To reopen the file or reopen the case, the matter, and retry. The second prayer is for bail pending retrial. And then the third would be for costs.
The third would be?
Costs.
All right. I'm coming back to that question. Let me project another question as well. Let me project another question. That is 2017 question, question 6. Somebody read it quickly. No, let me move up. Give me 1 second. Question 6. Somebody read. We're just reading it. Somebody quickly, guys. There's so many here.
We cannot see it, Mwalimu.
What do you mean you cannot see it? I can see the question on my all devices. You can't see question 6?
It's visible, Mwalimu.
We can see it.
Read it. Omwanga, leave and come back.
Question 6. Mr. Vorha was convicted of the offense of murder contrary to Section 203 as read together with Section 204 of the Penal Code and sentenced to suffer death. His appeal against the said verdict was dismissed by the Court of Appeal in a judgment rendered on 10th of January 2017. He did not contemplate a further appeal to the Supreme Court as he could not meet the requirements of Article 163(4) of the Constitution. Mr. Vorha has now received information that Mr. Beye, who he allegedly killed, is alive and woke up from a coma that was occasioned by an accident he was involved in before he was allegedly killed. It is now apparent that the body of the deceased that was burned beyond recognition by the fire started by Mr. Vorha was, per the High Court judgment, was not that of Mr. Bey. Mr. Bey has since returned to his family, where celebrations have been held for the miracle. You have been retained by Mr. Vorha to advise him on the available remedy and his chance of success. Advise him.
Yes, thank you. Now, in this question, you are not drafting anything. You're just advising him. So, guys, remember the guidelines when it comes to questions asking you to advise. What, where, when, how. Okay? What, where, when, how. So, somebody quickly advise Mr. Vora. So you have seen in all the 3 questions we have gone through. I don't know whether 3 or 4. The question that we've seen, the constant thing is that they are convicted of an offense, and then new evidence comes later when they can't appeal. Okay, they have new evidence when they can't appeal. So advise Mr. Vora. Somebody. Amwenda, can you see the question now?
Normally, I think my screen has hanged. I'm even unable to leave.
You are unable to leave. Do you want me to leave you?
Yes, kindly.
Okay. I've left you. Join again. All right, so somebody advise this guy so that we can close the class and come back in the last class that we'll have to discuss now the special proceedings. But I hope you know now the tune of questions on retrial. Okay, questions on retrial. Okay, so somebody. There's only one question remaining on retrial. It has been set around 4 times, and I've given you 3 of them. There's one remaining. Yes, Kamiri John.
Yeah, the first thing to advise the it's Mr. Vola.
Vora, not Vola. Watu from the mountain. Vora. Sema Vora.
Yeah, Mr. Vola is that number one. He starts no chance to appeal.
No, just stop there. Now stop there. That is not an advice. You can't tell somebody you stand no chance to appeal. Guys, I've given you always the roadmap to questions asking you to advise. Tell them what can they do. Okay? Where do they do that? How do they do that? When, which is the grounds of doing that? Full stop.
So, what can Mr. Vola do? Number one, he can.
Don't use the word can. Don't use the word can. Advise him now. He's in your office. What do you say? Number one,
Mr. Vola should apply for a retrial. Where? At the High Court.
Okay. How?
How? Through notice of motion with supporting affidavit.
And then why?
Why?
Which is the question of why? Why?
There is new and comparing evidence that he did not commit the offense, since offense was murder, and for murder somebody must have died. The person he was accused to have murdered is alive and secure.
Next ground, that is the first one. There's new evidence. Next one is somebody else. What is it? Guys, there must be 2 grounds. For a trial, there must be 2 grounds. The first one is which one? Yes, Jamal.
The new evidence must be compelling into a point that it has the ability to change the verdict of the.
That is not the threshold for new trial. The first one, as like we've said, that is the first one. The new and compelling evidence. What is the next one?
The evidence was not available during the trial.
No. That is still part of the new and compelling evidence. Ngeno Kipto, what is the second ground for retrial? For this application to be successful, what is the second ground?
Exhausted the appeal channel.
Yes, that he has exhausted his chances of appeal. You are being told that he had appealed until the Court of Appeal, which was dismissed, and then he didn't go to the Supreme Court because he could not meet the threshold under Article 1634. So, guys, there are 2 things that must be there. The first one is new and compelling evidence, which is an important evidence by all means and all chances. Number 2, this evidence is available at the time when Mr. Vora cannot appeal. And why can't he appeal? He already exhausted his chances of appeal. That is how you address that question. So first, what do they need to do? You make an application for orders of retrial before the High Court. Okay, how do you make that application? The application is done in a notice of motion and a supporting affidavit, praying for orders of retrial and bail pending retrial. And then, what are your grounds that Mr. Vora, there's new and compelling evidence that Mr. Vora, your client, did not murder Mr. Beye as alleged in the as previously alleged, as Mr. Beye has woken up from a coma, and of course is already at his home and everybody is celebrating. That is the aspect of new and compelling evidence. And then secondly, that this new evidence has been made available at the time when Mr. Vora cannot appeal because he has exhausted his chances of appeal up to the court of appeal, where his appeal was dismissed. Okay, now that is the advice you give. Remember, guys, don't say can, or the first thing this person can know. What can Mr. Vora do? Where do they do it? The High Court. How do they do it? Notice of motion and supporting affidavit. What are they praying for in that? What are the grounds? Full stop. That is the advice you give somebody in all instances. Tell them what they need to do, how they do it, where they do it, and the grounds of doing it. Guys, anytime you get a question asking you advice, start with what they're supposed to do, how they do it, what they are, if it's an application or a pleading, what are they praying for, and then the grounds. Why do you think they should pray? They should do that application. Why do you think that is what they're supposed to do? So the grounds, the when will come under that. And with that, you get your 10 marks. Guys, that is a question on retrial. This retrial, guys, is different from the retrial, which is the power of an appellate court. The appellate court can also order for a new trial if the appellate court is convinced that this matter was not tried efficiently. It can order that the matter be retried back, be sent back to the trial court for retrial. That is different. That is a power of the appellate court. But this retrial under the Constitution, where there's new evidence and there's no right of appeal, is a power of the High Court specifically, and it is only undertaken as per Article 50, sub-Article 6. Jonjo? Final questions. Final questions, and then we can have John. Samora, start with you.
Mwalimu, I was asking that in appeals, somebody who has pleaded guilty cannot appeal. But now in a retrial, when maybe a case that somebody was told or was coached to plead guilty, and then another compelling evidence comes later, can they apply for a trial?
There's no compelling evidence there. First, a person who pleaded guilty can plead guilty, can appeal. A person who pleaded guilty can appeal. We talked about that proviso. We said if you pleaded guilty, you cannot appeal only to the extent of the conviction. But there are instances where you can appeal. Number one, where you didn't understand the charge. The plea of guilt was not taken voluntarily. You didn't plead guilty voluntarily, or you didn't even understand why you pleaded guilty, or you didn't understand what you are doing, or you are of unsound mind when you pleaded guilty. There are a lot of dynamics around plea of guilt. So don't say that a person who pleaded guilty cannot appeal. No, that is wrong. They can appeal if they meet certain qualifications or certain standards. Okay? Even in that instance, there will be no compelling evidence. Okay? There will be no compelling evidence in that instance.
Thank you, sir.
All right. Lastly is Ngeno Kipto, and then you can have John there. Ngeno?
Mwalimu, just out of curiosity, we are looking at, in these instances of retrial, we are being told someone testified in the first instance and now wants to retract. Mm-hmm. Now, what actions can be taken against such persons?
It depends on how they testified. If they testified under oath, Of course, you know that is 7 years in prison. The offense is escaping my mind. What is the name of that?
Perjury.
That is perjury. That is perjury. 7 years in. If you lie under oath, that is perjury. Okay, so of course, number one, the state will compensate you depending on if it was a mistake of the state. Every case will have its own dynamics. Why were you convicted? Okay, if you are convicted on a testimony of someone, then number one, they go in for 7 years or more, depending on the nature of their confession. And then number two, you could institute civil proceedings against them for the time that you spent in, jail. Yeah. Sabusaga, lastly.
Okay, thank you, Mwalimu. Mine is a slight clarification. When you're doing that application, the respondent, is it the DPP or is it the Republic?
The Republic is a respondent. The DPP is not a party. The DPP is always the advocate. The DPP is an advocate representing the Republic. The Republic is usually the party represented by the DPP. Are we together? So it is Mr. Vora versus Republic. The prosecutor is just an advocate representing the Republic. All right?
Yes, thank you.
All right, guys, the recording has been stopped. Please help me to help you by asking for this recording now.